This is going to be the third lecture on civil liberties, dealing with the rights of the accused, which is found through the Fourth through the Eighth Amendment, and the right to privacy. All right. Well, the rights of the accused includes the Fourth, Fifth, Sixth, and Eighth Amendment. Okay. And the Fourth Amendment deals with primarily unlawful search and seizure. The Fifth Amendment protects individuals against double jeopardy, self-incrimination, and due process. The Sixth Amendment concentrates on the right to counsel, the right for defendants to confront a witness, a speedy trial, and a trial by jury. And the Eighth Amendment centers around the protection against excessive bail and cruel and unusual punishment. Okay. But remember, the government has to balance, again, this balancing act between protecting individuals from wrongful conviction, i.e. their due process, versus controlling crime. And so society always has to think about whether or not they are putting people in jail for wrongful conviction because of some violation of due process, and their duty to control crime in society. And remember, the Fourth, Fifth, Sixth, and Eighth Amendments didn't apply to states before the 14th Amendment. So all these cases are really after the Civil War, and some even well into the 20th century, before the rights of the accused are really applied to the states. So if you watch an old black and white movie in the 50s and 60s, for example, you will see the police being very rough on the defendants, and this is before Miranda Rights were put into place. So police didn't have to read the defendants their rights, for example, before the 1960s. And so the way defendants are treated in those movies is very different than what we see today. And there are, again, this is as a reminder of what I said in the first lecture, there are some important rights guaranteed to the accused directly in the Constitution. The writ of habeas corpus, again, remember that's a court order directing a public official who's holding someone in custody to bring that prisoner to court and explain the reason for their confinement. And again, the purpose of the writ of habeas corpus is to prevent law enforcement officers from detaining individuals without some sort of cause. And so if the judge finds that a prisoner is being unlawfully detained, the judge is going to order their release. And so the Supreme Court has never sanctioned a suspension of the writ of habeas corpus. Again, the exception, as I mentioned before, is in the Civil War, where Lincoln suspended the writ of habeas corpus in certain areas. But in the case that occurred in Milligan in 1866, the Supreme Court ruled that the president had acted unconstitutionally. But since the war was over, the decision had no real effect. But we do see this being brought up today in the War on Terror. In addition, the Constitution prohibits bill of attainders. Again, that's a legislative act inflicting some sort of punishment without trial. And it also prohibits ex post facto laws. Those are retroactive criminal laws that work against the accused. So we're going to look at the selective incorporation of the 14th Amendment to the states of procedural rights through this particular exercise of looking at the rights of the accused. So let's start with the Fourth Amendment protection against unreasonable search and seizure. Okay, so this is basically what the Fourth Amendment focuses on, is it protects you and I, the citizen, against unreasonable search and seizure of our person, of our house, of our cars, all those types of things. Okay, so in order for the government, that is the state police, federal police, whomever, in order for them to do a legal search and a legal seizure, they have to have warrant. So you have to have a warrant for a search that's issued because there's probable cause. Judges cannot issue search warrants for fishing expeditions. That is to see if a crime has been committed. Okay? You must have some probable cause, the police must have some probable cause that a crime has actually been committed. Therefore, the warrant usually has to specify the location to be searched and the specific item that the officer is looking for. However, there is an exception if the police, in the course of a valid search for a specified item, find some other illegal items. So if the police have a valid search warrant to search an individual's house, and they've decided that what they want to do inside their house is grow a lot of pot, if it's in plain view, they're not going to be protected against unlawful search and seizure because the police were doing a legal search with a valid warrant and happened to see other illegal items. Okay. There are some exceptions, okay, but basically, as long as you have a valid warrant, any other type of crime that they see that has been committed is fair game. Okay. Well, what about drug testing? Okay, is it illegal for the government to want to drug test an individual? The Supreme Court has ruled under the Fourth Amendment that mandatory drug testing on certain individuals is going to be reasonable. So for railroad workers, for example, federal law enforcement, students participating in athletics. Okay. However, the Supreme Court has also struck down a Georgia law requiring drug testing for candidates to public office. They see that as unreasonable. So basically where the court has drawn the line is that drug testing to protect public safety or to protect children is reasonable, while drug testing the general public is not. So if your job is one that the public relies on for safety, so if you're a bus driver, an airline pilot, some sort of safety worker, then you are going to have to probably be drug tested. Okay. But just picking someone off the street and demanding that they have a drug test, that is unconstitutional. All right. There is something called the exclusionary rule, and so you're going to want to remember this case, the Mapp versus Ohio case in 1961. And here's just a little bit of the background. The police in Ohio were tipped off that a woman, Miss Dolly Mapp, was harboring a suspect who was suspected of a bombing incident. The policemen then forcibly entered Dolly's home, claiming that they had a warrant to search for the bombing suspect. They found no bombing suspect, but did find evidence of participation in illegal gambling and possession of some obscene materials. Both were violation of Ohio state law. Mapp was convicted by a court for illegal possession of obscene material. However, no warrant was really ever produced. In fact, the police only claimed they had a warrant. They did not really have a warrant to enter her home. Okay. The Supreme Court ruled that the evidence obtained in this search could not be used in court under something called the exclusionary rule. And the exclusionary rule says that evidence found in an illegal search or resulting from an illegally obtained confession may not be obtained or admitted into trial. Obviously, the exclusionary rule is unpopular precisely because the result is to free someone who is shown to have committed a crime. However, if the police err and don't have a valid search warrant and find evidence of some sort of crime, that evidence will be tossed out. If you watch Law and Order on TV at all, you see this being used all the time to toss out evidence because of improper police procedure. In recent years, the application of the exclusionary rule has been loosened. Okay. Federal courts can make a judgment regarding the nature and quality of the intrusion. And so it's really a case-by-case event, but basically if the police err, if they do not have a valid warrant and search your home and have found evidence, that evidence could be tossed out because of the exclusionary rule. And that's the issues associated with the Fourth Amendment. The Fifth Amendment is the amendment that deals with due process. And it requires that an indictment be issued by a grand jury before a person can be brought to trial on a felony offense. So federal prosecutors must convince a grand jury that a reasonable basis exists to believe that the defendant has committed a crime and he or she should be brought to trial. But grand juries rarely refuse to indict an individual, and a lot of states don't require a grand jury to bring a case. The other part of the Fifth Amendment's due process that you're probably more familiar with is the right to not self-incriminate and the right to have counsel. This is the Fifth Amendment as well. The burden of the proof rests with the states. The individuals should not be forced to contribute, obviously, to their own prosecution. And that is Mr. Miranda on the right-hand side of the photo. This is where you get the Miranda warning. This is the case of Miranda v. Arizona in 1966. Mr. Miranda was sentenced to 20 to 30 years for kidnapping and raping a young woman. Miranda was interrogated for 2 hours, confessed, and was subsequently convicted. Miranda was an 8th grade dropout who did not know he did not have to talk to the police. At trial, no evidence was presented that Miranda had ever been told that he did not have to talk to police or that he had the right to even have a lawyer. The Supreme Court tossed out his conviction and made the Arizona courts retry the Miranda case. He was tried again without the confession. He was convicted and served 11 years before he was paroled in 1972. And today, anyone arrested as a criminal suspect is read their Miranda rights. And you probably know this by heart, but here's an example of the Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned. If you cannot afford a lawyer, one will be appointed to represent you before any questions if you wish one. Okay, and so this is an example from the San Francisco Police Department. So that's your Fifth Amendment Miranda warning rights. Okay. Some additional rights of the accused is the Sixth Amendment right to counsel. Okay. The famous case is the Gideon versus Wright case in 1963. Mr. Gideon was charged in a Florida state court with having broken and entered a pool room with the intent to commit a misdemeanor. However, this particular offense was a felony under federal law. He appeared in court without any funds and without a lawyer, and the petitioner asked the court to appoint counsel for him. So Mr. Gideon, who doesn't have any money, doesn't have a lawyer, asked the court to appoint counsel for him. The court refused to appoint counsel because in Florida the state law provided counsel only if the defendant was charged with a capital offense. Gideon responded, "The United States Supreme Court says I am entitled to be represented by counsel." Gideon was convicted of 5 years. With no lawyer, he wrote his own appeal to the Supreme Court demanding his right to counsel. And the Supreme Court agreed and ruled that equal protection under the 14th Amendment requires that free legal counsel be appointed for all indigent defenders in all criminal cases. So basically the Supreme Court is saying the Sixth Amendment applies to the state of Florida through the 14th Amendment's Equal Protection Clause requiring legal counsel for those who cannot afford one themselves. So that is the Gideon case. An additional case, the Escobedo case, a year later, further specifies that suspects are entitled to meet with their counsel as soon as police investigation focuses on them or once the process shifts from an investigation to an accusatory position. So you're allowed to talk to the police even during the investigation phase. You don't have to wait to be arrested to actually speak to an attorney. All right, then we have the Eighth Amendment. This is the Punishment Amendment, and it deals with a variety of issues, including punishment as well as bail. But one of the issues that comes up with the Eighth Amendment is racial profiling. And many argue that many of the sentences, the punishment phase, is in violation of equal protection laws under the 14th Amendment because of racial profiling. And we see this with police. There's several different movies highlight racial profiling. If you saw the movie Crash, that's a good example. You see this in police shows all the time where someone who is in a neighborhood, if they are a minority in a neighborhood, the police will question what they're doing in that particular neighborhood. We see racial profiling in the war on terror. So how does the United States wage a war on terror without racial profiling? So this issue of punishment and bail set based on race is an important issue of the Eighth Amendment. And furthermore, what is considered cruel and unusual punishment? Okay. So racial profiling is one issue, and then what is cruel and unusual punishment? The Supreme Court has ruled that the death penalty is not cruel and unusual. When the death penalty has been suspended, it's not because of the idea that the death penalty is cruel and unusual. It's basically because of the way it's being applied has racial undertones to it. So that has been an issue with the Eighth Amendment in the past. All right. Well, with the Eighth Amendment comes the issue of the death penalty, and we know that Texas is the leading state when it comes to executions of capital offenses. So if one is thinking about committing a capital offense, maybe one should not do that in the state of Texas. So this is as of November 2009. Texas has had 446 executions since 1976. Before 1976, in the early 1970s, the Supreme Court required all states to stop using the death penalty and declared it to be unconstitutional based on the way it was being applied because of the discrepancy between whites and blacks and who was on death row. So this is why we see this date, 1976, is when the states could start again using the death penalty. And you can see how states in the South are much more likely to use the death penalty than the states in the North are. All right, this is a map that shows what type of death penalty can be carried out. And in most states, the green, this is where lethal injection is the method of execution. They still electrocute individuals in a couple of states, as you can see. Those states in the purple, it's either lethal injection or electrocution. Those states in the blue will even let you be gassed if that's the choice that you have. And there are a few states that still allow hanging. And then there are some states that will allow you to stand before the firing squad. Okay, so many times the person being put to death has some choice in the matter. Okay, this is the real issue when it comes to the death penalty. Okay, over 79% of completed capital case involves white victims, even though nationally only 50% of murder victims are white. So what this is saying that when it comes to applying the death penalty, the punishment is going to be more likely if the victim was white than if the victim was a minority, which is out of sync with the percentage of people who are victims, as we see here. 50% of all victims are white. 79% of the cases where whites are victims, the defendant is put to death or is on death row. You see the discrepancy there. And that's one of the debates about the death penalty, of whether or not the application of the death penalty is racially motivated. All right, what about the right to privacy? You will not find in the Constitution anywhere where it says there's a right to privacy. It's not explicitly written down, but it has been interpreted by the Fourth Amendment as well as some other amendments like the Ninth Amendment. The Ninth Amendment is referred to most often in discussing the right to privacy, and the Ninth Amendment says, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." All right, well, a lot of people don't, the first question is, what does all that mean? Basically, what they're stating there is that if it's written in the Constitution, these certain rights, that doesn't mean that it shouldn't be understood to deny rights to people in other cases. All right, so the right to privacy was first decided actually in the 1960s, in 1965. Okay, and the types of cases that the right to privacy generally deal with, and the case in 1965 was birth control. So the right to privacy when it comes to birth control, abortion, homosexuality, euthanasia, or the right to die, these are the issues that are surrounding the right to privacy. Okay. And again, the Ninth Amendment is where many people point to, but keep in mind that the right to privacy is really brought up through all these different rights. Because of the Fourth Amendment's right to protect you against unlawful search and seizure, you have a zone of privacy. You have a zone of privacy that suggests that your home, the things you do in your home, are private. The Ninth Amendment says, unless it's otherwise said somewhere else in the Constitution, rights shouldn't be construed as being denied to others, okay? So just because there's not something written down in the Constitution doesn't mean people don't have rights. So the Ninth Amendment and the Fourth Amendment is where we see this most often. So here's the Griswold case. It happened in the state of Connecticut. Estelle Griswold and a fellow doctor are convicted of violating the state's birth control law. Yes, in Connecticut there is a birth control law. Their crime was giving medical advice and prescribing contraceptives to married couples that asked for them. All right, so these are married couples who are asking for contraceptives. All right, they appeal their case, and the court rules that and said the following: while it may shock some of my brethren that the court today holds that the Constitution protects the right of marital privacy, in my view it is far more shocking to believe that the personal liberty guaranteed by the Constitution does not include protection against such totalitarian limitation of family size, which is at complete variance with our constitutional concepts. Yet, if upon a showing of a slender basis of rationality, a law outlawing voluntary birth control by married persons is valid, then by the same reasoning, a law requiring compulsory birth control also would seem to be valid. In my view, however, both types of law would be unjustly intrude upon rights of marital privacy which are constitutionally protected. So even though the federal Constitution has no explicit right to privacy, the judges refer to this zone of privacy that is built on other guarantees. We have due process of law, we have freedom of association, we have no unreasonable search and seizure. And so they come to the agreement that the law in Connecticut, that the birth controls, even by married couples, was illegal. The court ruled that the law was unconstitutional, stating that the state has no business interfering with the married couple's decision regarding contraception. It's important to note that the court did not use the Ninth Amendment, but referred to the freedoms that the other Bill of Rights imply regarding the right to privacy, i.e. a zone of privacy exists. So since 1969, the courts have ruled that individuals have a zone of privacy to which the government can't interfere, and the bedroom is one of the places where they believe they shouldn't be interfering, which leads to the question of abortion, and this is the Roe v. Wade case in 1973, and again it's based on the right to privacy. The ruling gives women the right to choose an abortion during the first 3 months of pregnancy. And since then, the debate has raged, with many cases winding up at the Supreme Court. Anti-abortionist activists, those people who are pro-life, have scored some victories. So, for example, the use of government funds to pay for abortion has been banned. Abortions cannot be performed by public employees in public hospitals, for example. But pro-choice activists has also scored some victories. For example, in 1992, they upheld Roe v. Wade, that women have the right to an abortion during the early months of pregnancy. However, the state can place parameters or regulations on the practice as long as it doesn't place an undue burden. We have seen the case of abortion reach the courts again even recently, with ideas about requiring individuals who want to have an abortion have a sonogram or an ultrasound to hear the heartbeat, things of that nature. So the abortion issue is not dead. It's going to be an issue in the upcoming election about what the candidate's position is on abortion. And then you have partial birth abortion that deals with the idea that abortion at delivery is sometimes the most appropriate medical procedure for protecting the life or health of the mother. So the Nebraska law prohibiting the practice was struck down by the Supreme Court. Okay, so Congress has passed a law since then making partial birth abortion illegal, and the Supreme Court has yet to really rule on that. So abortion is going to be, again, a debated topic. It always comes up during Supreme Court justices that are being interviewed before the Senate Judicial Committee if they're being nominated for the Supreme Court. So, for example, during the Roberts nomination proceedings, Senator Dianne Feinstein from California indicated that abortion rights was a crucial issue for her. She said, "For me, one of the most important issues that needs to be addressed by you, that is Mr. Roberts, is the constitutional right to privacy. It would be very difficult, I said this to you privately and I say so publicly, for me to vote to confirm someone to the Supreme Court whom I knew would overturn Roe v. Wade. So we see the issue of abortion in the court cases and the right to privacy, dealing with Supreme Court judge nominations, and we'll see it in this particular road to the president's, to the election for the presidency. All right, let me just kind of conclude here. This has all been about civil liberties. These are the types of things, and you can see over there in the Bill of Rights, the first 10 amendments, but the amendments that really apply. These are the things that protect you against government. You're protected against the government in terms of your freedom of speech, religion, and press, your right to bear arms, your right to have protection against unwarranted, unlawful search and seizure, your right to a speedy trial, the right to have a trial by jury, the right to have bail and fines and that sort of thing. And all these are the Bill of Rights that's applied to the states through the 14th Amendment through selective incorporation. Okay, there's reviews available at the textbook online. You have the review questions that I have posted for you, so make sure you go through those and know what I expect you to study for the next exam. And then the next week we'll have a lecture, probably in 3 parts, or at least 2 parts, on civil rights.